We all know that these sorts of legal wranglings are distraction. How much impact do you think it will have on a business model?
I think the distraction comes from the number of people inside the company you have to commit to support the litigation. We don't know what that number is, but the experience in other major cases is that this can be a significant drag on the company. You have also the inhibition that comes from the pending lawsuits. Companies don't want to provide additional ammunition for prosecutors. It means that they're not quite as agile, not quite as adroit in developing business programs. I realize these are somewhat intangible consequences, but I think cumulatively, when you take all of the developments we've just been talking about in the United States and abroad, it's an avalanche of regulatory oversight that has to sap, to some extent, the creative energy of the company.
Mr. Kovacic, we sometimes talk about on this program regulating through the courts, a legal action to get a result that's the bigger picture. Is there an avenue where Apple and the DOJ can just work this out outside of court?
I would think there's always the possibility of reaching a solution. The solution, though, is going to have to be one that persuades the Justice Department that the overall aim of any specific settlement is not subject to evasion by additional adjustments in the business model. They'll have to be confident that the solution is one that they can monitor and oversee effectively. I think that there would be a willingness to discuss settlements, but a major message that has come from the agencies in the U.S. in recent years is a great deal of skepticism about the efficacy of many settlement arrangements and doubts about how readily you can implement them and be effective.
In your reading of the suit itself, do you think the DOJ has a point here?
They do have a point, and the point is one that, in a sense, involves, again, a collection of intangible considerations. But there's anxiety about the possibility that incumbent firms that have a significant market position will, through a variety of tactics, diminish the emergence of alternative technologies and new business models. That concern might be very much the feeling that antitrust law failed in the last 30 years to deal effectively with the emergence of new tech. And I believe a state of mind, a perspective that has a tight grip on the agencies is that they're not going to allow the perceived permissiveness of the past to continue. And it means that they're going to dig in and look carefully at anything that appears to be an effort by an incumbent to see that new technologies, new business approaches do not emerge.
This is DOJ action. We've seen FTC have a similar focus. But sometimes this is political. In an election year, does this sort of continue?
I'm going to give you a bit of speculation that I could never prove in a rigorous way, but I noticed that President Biden's opponent, in many instances, has been skeptical of tech. Now, that skepticism has been focused in particular on the information services platforms that are involved in advertising, involved in social messaging. But it was Donald Trump's Justice Department that initiated the Google search monopolization case. It was Donald Trump's Federal Trade Commission that began the lawsuit against Meta for its acquisition of Instagram. It could entirely be possible that, at least for tech, given the way their political contributions go, given his concern about the role they've played in his own electoral process in the past, that he may look at the FTC and the Department of Justice and say, keep up the good work.